Volunteer Network, which is essentially a multi-stakeholder consultation to reflect on the paralegal volunteer scheme and its implementation over the last 15 years. As an organization, the Migration and Asylum Project, or MAP as we call it, has been engaged in providing direct assistance at the grassroots for over a decade. MAP's mission is to end the marginalization of those whom we consider amongst the most vulnerable of communities, internal migrants and forcibly displaced persons, with a particular focus on women and girls. We do this essentially by adopting a participatory multi-pronged approach to empower our target communities through legal awareness, quality legal aid, strategic litigation, advocacy, research, and implementing innovative technological interventions. Critical in helping us in this mission for nearly 5 years now have been our network of over 300 paralegal volunteers who have been intensively trained by us in labor and sexual and gender-based violence related laws, and who have collectively assisted us in reaching over 25,000 migrants, mostly women, by facilitating access to essential documentation, government welfare schemes, protection systems, law enforcement agencies, and the judiciary. This particularly in the period of the COVID-19 pandemic and thereafter. In our experience, this is a remarkable workforce that could make a huge difference on the ground, provided, of course, they are utilized properly, trained intensively, and adequately incentivized. Now, 15 years since they were operationalized as legal first aid responders by the National Legal Services Authority, or NALSA, we thought it was a good time to evaluate and reflect on the functioning of the scheme, and with it, and especially with some of you who may have worked with them for much longer than we may have, to set a roadmap for the next decade or so. To begin with then, we are extremely privileged to have with us Justice Sanjay Kaul, former judge of the Supreme Court of India and former executive chairperson of NALSA, during whose tenure the first ever regional conference on access to legal aid to strengthen equal access to justice for all in the Global South was held. This was preceded by a number of national conferences on the same topic, demonstrating his passion for the issue. I'll just introduce Justice Kaul before I request him to come on stage. Justice Kaul graduated with an honors in economics from St. Stephen's College, Delhi University in 1979. He obtained his LLB degree from the Campus Law Center in 1982 and enrolled as an advocate with the Bar Council of Delhi that year. He practiced mainly in the commercial, civil, writ, original and company jurisdictions of the High Court of Delhi and the Supreme Court of India. He remained advocate on record, of the Supreme Court from 1987 to 1999 and was designated as a senior advocate in December 1999. He was appointed senior counsel for the Delhi High Court, was on the senior panel of the Union of India and served as the additional senior standing counsel for the DDA. Justice Kaul has been a judge with the High Court of Delhi and was also elevated to Chief Justice of the Punjab and Haryana High Court as well as of the Madras High Court. He was appointed a judge of the Supreme Court in 2017, where he retired recently. I now invite Justice Kaul to kindly deliver the keynote address.
Very good morning to all of you. Firstly, let me take this opportunity to thank the MAP for inviting me to deliver the keynote on an issue that I have worked closely in the executive chairperson of the NALSA. I also commend the work for the Migration and Asylum Project has and continues to do for empowerment of its target communities through legal awareness, quality legal aid, strategic litigation, advocacy, research, and innovative technological interventions. In fact, the organization all works closely with the NALSA, Paralegal Volunteer Network. Over 300 paralegal volunteers in Delhi have been trained by the MAP, who have assisted in reaching over 25,000 migrant workers, mostly women, and work towards resolving their grievances. The topic for today's event is Bridging the Justice Gap and Empowering the Paralegal Volunteer Network, with an emphasis on the Learning from Paralegal Volunteers program and the way forward. The agenda for today beautifully captures the indispensability of a robust and strong PLV network, which is imperative to bridging the justice gap in the country. The justice gap signifies the mismatch between the demand for legal services and their accessibility. It underscores the systematic challenge of the justice system in extending support to those most in need, accentuating the struggle faced by the marginalized individual in accessing legal assistance. The Parliamentary Standing Committee on Personal Public Grievances, Law and Justice presented its 143rd report on 7th of February 2024 on the subject of reviewing the working of Legal Aid and the Legal Services Authorities Act of 1987. The committee, while preparing the report, had held interaction with the Chief Justice, Justice Sanjay and myself on the issue of furthering access to justice. The report highlights a jarring reality. As per India Justice Report 2019, since 1995, only 15 million individuals have availed themselves of the legal aid, despite over 80% of the population being eligible for such assistance. This begs the question: are impediments to access to justice function of the litigant's apprehension, or is something amiss in the larger system? In my view, the answer is quite simple, albeit requires an effort at the grassroots levels. This becomes apparent from the data from the National Crime Record Bureau, which underscores the disproportionately large number of incarcerated persons in Indian jails belonging to the marginalized communities compared to their share of the population. Significantly, almost two-thirds of these individuals are still facing trial and remain behind bars, often for a period exceeding the statutory punishment. In other words, despite not having proved guilty, they remain in jail, giving up their freedom to a larger part due to an inability to engage a competent lawyer. This stems from both lack of awareness and knowledge of one's legal rights, as also avenues now available to enable access to justice. It is this vital function of bridging the gap that a paralegal volunteer performs by acting as an intermediary between the vulnerable and those who need legal assistance the most and the legal service institutions. A paralegal volunteer, first and foremost, educate people, especially those belonging to the weaker sections of the society, of their rights, as also their duties and obligations. For this purpose, NALSA prepared a comprehensive scheme for paralegal volunteers with a focus on strengthening engagement and involvement at the taluk level. Emphasis was laid on PLVs are imparting awareness, but also be equipped to counsel and encourage settlement of simple disputes between them. This would no doubt benefit the everyday man by obviating the need to approach court and start what will invariably, in most cases, be a long drawn-out struggle. In the event the dispute is one which is incapable of being resolved mutually, PLVs would bring such parties to the area centers, where, with the assistance of secretary in charge, it could be referred to Lok Adalat or Mediation Center. People seeking good, quick resolution of disputes instill a degree of confidence in the legal framework and remove unfounded apprehensions in seeking legal recourse. Speaking for myself, I have been a great votary of mediation itself. It is my belief that no court system can cater to so many litigations. Whatever number of judges we may increase, whatever the number of assistance we may provide. And countries across the world where they have faced volumes have used mediation very successfully. I've had the opportunity to examine this in an exchange program both in the US and the UK. And when we went to California to study the system, almost 97 to 98% disputes were resolved through mediation, arbitration, other alternative dispute resolutions. They may not have the equivalent of a Lok Adalat. Now, in our country, we still want to carry on a 99% dispute resolution through a system. and where a large percentage of litigation, even at the apex court level, more than 50%, is with government as one party or the other. Now, therefore, one of the biggest challenges is how to get the government into a mediation, which they don't like, but at least the private parties can be assisted in this. My own experience is that mediation works both not only in matrimonial matters, where it has been definitely a great success, but in personal disputes, business disputes. Post-retirement, have had an opportunity to do mediation and trying to resolve these disputes. And there were complex disputes, commercial disputes, but I've had a great experience of seeing the success of it. Because it's only the mediation process where you tend to listen to both the parties. The court is short of time. Somebody will present a case, another person will set the case, and the litigant sitting at the back feels that what he wanted or what his problem was is not what the resolution has been. I sometimes often give an example of a court system. So in the Delhi High Court, there used to be these small kiosks outside where different items used to be served. So one of the litigants must have been unhappy, came there and was standing next to the juice counter, which used to serve these cold coffee and milks and other things. And he ordered, maybe ordered elaichi milk, was given a cold coffee, or the reverse. And this story is related to me by a former Chief Justice of the High Court. He said this fellow asked him कि मैंने क्या मांगा था, तो he said कि cold coffee, तो आपने दिया क्या है, तो उसने कहा कि गलती से इलायची मिल्क दे दिया. He tells them कि ये पिछले जन्म में कोई जज होगा, मांगो कुछ देता कुछ और है. Now, see, this is the challenge. Sometimes, why mediation, one of the basic fundamentals of that is that the litigant controls the process to understand what he wants, not what a court system may give to him. That's why a training of mediator begins by giving the fundamental example that if there are two people claimants, a court will divide the orange into two parts and give it to them if you are dividing an orange. But the mediator will go behind the requirements and see what is to be done. So if he feels that one person needs the juice, another person wants to make a marmalade out of the rind, he will segregate the two. This is the fundamental advantage of a mediation process. And paralegal volunteers at the base level, at the level where people are seeking their problems, can help in resolving these disputes through a mediation process by approaching them. After all, PLV is also doing, apart from awareness, a mediation process. That's why I feel all PLVs should be trained for mediation, which is for anybody else. How to resolve small disputes at taluka, village levels without requiring a recourse to the legal system and the labyrinth of what goes on after that. The training of paralegal volunteers as envisaged by NALSA is concentrated on the PLVs conveying compassion, empathy, and genuine concern, and willingness to extend the voluntary service. So it's their focus, their working style, which helps out, which is not concerned with the legal nuances all the time. The simplest document is never done legally, as they say. People try to understand what has been written. That's how law is evolved and developed. A training program covering the basic communication skills, introduction to basic statutes to advanced courses of counseling, mediation and alternative dispute resolution to pre-litigation mediation should be voluntary for PLVs, as I was just mentioning. Some of these trainings we go as judge. When mediation started, I sat with the other mediators and went through a training. I went through the basic training, went through the advanced training, not once, many more times. And even working as a judge, I thought it helped me. It helped me not only from point of view for understanding what matters can be referred. That's the training which we are now giving to High Court judges, also sending people from mediation, which we are sending, that let the judges be trained on referral aspects. But I think in judging aspects, it helped me. It helped me understand that sometimes the litigant standing in the back and trying to raise his hand, while we are not supposed to listen to him but only to the lawyers, possibly feels the lawyer has not been conveying what really is the rub so far as he's concerned. I was very reluctant as a judge to permit anybody to do so, but having gone through mediation, I used to sometimes permit them for a couple of minutes to have his say, because I thought that gave him that ease of being able to say what it is. But the legal system is so packed, so volume is so large, that judges don't get that extra time to be able to do what is required or to listen to the story which is necessary for some solution. And therefore, the para-volunteers are the people, if properly trained, they are the ones who can find solutions to large number of problems, which in the socio-economic scenario which our country faces are bound to arise at the ground level. The purpose of this comprehensive regular refresher course for PLVs is to enable them to assume and discharge larger roles, which in my view must include educating people, especially those at the fringe of society, of their rights to live with human dignity, to enjoy all the constitutional and statutory guarantees rights. This is most important, because I think awareness of law is most important. Existence of law is different from awareness of law, and especially I would say where rights of marginalized sections and women are concerned, a lot of them are not aware of what they can get. And this is also the view of the men folks, I think, who feel that, I've seen this in say, partition suits, etc., saying they would still say the woman doesn't have a right. So how to educate different people to understand what rights different sections today has as per laws which have been enacted is most important. Communicating effectively with people and putting to them in simple terms the nature of their disputes, issues, problems, and how they can approach the local services committee to resolve the same. Paralegal volunteers at village taluk levels, being essence the front line of the legal and justice delivery system, must keep a vigil on the transgressions of law and bring them immediately to the notice of the TLSCs to enable effective remedial actions by the committee. When a PLV receives information about the arrest of a person in a locality, a visit to the police station and ensuring that the arrested person gets legal assistance if necessary through the nearest legal service institution must follow. Counseling the victims of crime and ensuring they get a proper care and attention. This is an important principle of victimology also, because I remember in Chennai releasing a book written by a lady who referred to recognizing the victimology principle also, because that is not that one person suppose is killed, it's the ramification of the family and how to understand it. Visiting jails, lockups, psychiatric hospitals, children's homes, observation homes, and ascertaining the legal services needs of inmates. Assisting the district and taluk legal services committee for organizing legal awareness camps in the areas in operation, and working in the legal aid clinic set up under the NALSA Legal Aid Clinic regulations of 2011. Given the expanded role of PLV at the grassroots, it is also important to focus on the background of people that must be encouraged to volunteer, which may include teachers, retired government servants, Anganwadi workers, members of women neighborhood groups. These individuals not only commend and respect in the local community, but also are in touch with reality on the ground and would therefore serve as an effective PLV with the ability to possibly resolve disputes in the source. I, in one of the state level meetings, conferences, met a couple of people. One of them was an elderly gentleman who was a businessman otherwise, but decided to volunteer for it. And he was greatly respected because people found that he generated the right kind of solutions. So there is an aptitude which also comes in. When we train mediators, I used to see that some of the very good professional lawyers, it did not work out as a mediator. You need that little bit more patience, that hearing ability. And sometimes there were people who may not have had the best of success as lawyers, but great mediators because of their ability for empathy and listening. So the skills required are different. And similarly in PLVs, the opportunity must to see that those people who have these skills are able to work and help out. I must also add that technology has been a great enabler in the endeavor to provide access to legal aid. with smartphones and interconnectivity penetration has opened new dimension in dispensations of legal assistance. NALSA introduced the Legal Aid Case Management Systems portal, which enabled aggrieved individuals to, in a few simple steps, file their grievance on the LACMS portal, which forwarded to the jurisdictional concerned district or Taluk Legal Service Committee for necessary action to be taken, including the first instance deputing a paralegal volunteer. All State Legal Services Committee now also maintain a separate website with a district-wise list of registered paralegal volunteers to enable aggrieved individuals to reach out PLVs in the district for immediate assistance of pressing situations. In fact, we've also taken out, I had the opportunity not only to help NALSA but also the Mediation Committee, and before I remitted office, we took out a directory of mediators and to distribute. If you don't have it, please take it. It has also mediators in every district and every area now identified who have already been trained. So at one go you can get where such mediators are available. Otherwise that used to be a challenge both for judges and for voluntary organizations like yours. In November 22, NALSA also undertook a pan-India campaign for the objective of bridge the gap between the institution and the underprivileged sections of our society by equipping them with legal awareness and ensuring delivery of legal entitlement to the eligible beneficiaries. Thematic areas covered under this campaign included spreading awareness about welfare laws and schemes enacted for empowerment of people, the Constitution of India, fundamental rights and fundamental duties, free legal aid services provided by legal service institutions, digital initiative for approaching institutions, the Vidhi chatbot, WhatsApp chatbot, legal aid case management system, legal services management system, online mediation portals, among others. Rights and remedies available under various laws. With the following activities undertaken to achieve its objective. So what we did was a door-to-door awareness campaign covering all villages, panchayats and subdivisions, mega legal awareness camps at district levels, production and dissemination of information, education and communication, exhibition showcasing the working of the achievements of legal service institutions, and ensuring cooperation of print and electronic media resource to extend it to the masses. The campaign successfully covered TLSCs and DLSCCs spread across 37 state legal services authorities. During the course of the campaign, 64,000 individuals were provided legal advice and counseling through paralegal volunteers, with the program saw participation of over 3 crore people. During my tenure as Executive Chairman NALSA, we conducted several campaigns, including for prisoners on specific and targeted delivery of legal services at a pan-India level. 3.55 lakh programs are conducted by the legal service institutions across the country, benefiting almost more than 3.2 crore persons. The 2 under-trial review committees campaigned in 2022 and 23 resulted in release of more than 50,000 prisoners who were otherwise eligible to be released, but the cases were not being reviewed for want of intervention. Now, this is one of the important aspects which we talked about as to how to make them aware of their rights. Reaching out to such mega population is not possible without the network of paralegal volunteers. The 42,000 PLVs of the legal service institutions are like the veins in the human body, spread across the length and breadth of the country. Commendable effort in framing PLV schemes has been made in particular by the Delhi State Legal Services Authority. A standout example being the pilot PLV scheme framed by DLSS for appointment of PLVs in police stations in respect of missing children and other offences against children. Following directions issued by the Supreme Court in the Bachpan Bachao Andolan, the DLSS scheme was circulated with all states to enable them to implement corresponding schemes locally with required modification. The pilot scheme was subsequently regularized, and the Delhi High Court, in a criminal reference made by the Principal Magistrate of the Juvenile Justice Board, is monitoring the implementation and scaling of the PLV schemes for appointing police stations in respect of missing children and their offence-involved children. Now, this is very important, I think, because you initiate things, but then continuing monitoring is required. Police is a law and order issue. Still, the feeling of how it should be done or the compassion will take a long time to come, and it helps in trying to keep on reminding them of it, which I think the PLVs can regularly do. I had the privilege of being party to the Satyendra Kumar Antil matter, which dealt with the bail jurisdiction in most comprehensive form. Judgment being penned down by my colleague Justice Sundaresh, where during the course of hearing we found that there were thousands of prisoners who had been granted bail, but they could not be released because of not furnishing of bail bond or surety. We immediately issued directions for identification of such prisoners and for urgent filing of requisite applications for ensuring their release. NALSA sprang into action, and within 3 months, more than 5,000 prisoners were identified and released. Thereafter, to resolve this issue institutionally, we had directed a suo motu case be registered regarding policy strategy for grant of bail. Directions were passed to ensure institutionalization of the process for communication of the bail orders to prisons through e-prison module, and to monitor the cases where the prisoner is not released within a 7-day bail order. Similarly, in Sonadhar, we ensured that process of premature release of prisoners is included in the e-prison module through coordination with the concerned authorities. The objective is, if technology is available, we must utilize it. If a person is not getting bail, the system must throw it up. So now if 7 days the person doesn't get bail, in the system there's a blip to identify and show that. And the PLV then take recourse to seeing why that is happening. It possibly needs some simple identification of the problem. Yet 5,000 cases post bail were pending. Forget the number of matters pending where bail needs to be considered or granted. Remission cases, huge number of remission cases are pending where a person has served the minimum sentence but had been lost track of. The family also lost track of him. So nobody was interested in it. That's the other challenge which was there. And then the remission cases would take a long time to evolve and develop, and we pushed for that because we thought that the system itself should identify instead of somebody approaching them. The system should throw up the names of people whose cases can be considered for remission, and they be considered within time-bound schedule. This, I think, is an example of how the court was able to restore justice with the assistance of the PLVs for those who could not be released despite grant of bail for only reasons of party and lack of awareness. Equally encouraging is the involvement of law students and law schools in conducting what are colloquially called legal aid drives organized by the legal aid clinics affiliated with the State Legal Services Committee. Law students, they are enthusiastic, they have vision, they have the zeal to do so. And law students visited the marginalized areas, spending time with persons aggrieved by issues that may require legal redressal. Students also assist in making first drafts of appropriate applications, petitions, alumni note work, serving PLVs not only to give law students useful insight. We often are critical of ourselves. We don't appreciate what is positive happening sometimes. There are problems, many problems, but there are also some things which are good, which are happening. I've seen one of my law clerks, for example, he was a graduate of the Bangalore Law School, worked with me, and then went back to work in this area as with the Delhi 5-year course, and still continues to work on the scheme. With his qualifications, he would be a absolute fit, and his abilities, I would say, into any big law firm. But that he devotes his time to it shows a commitment. And there are many like this. The issue is able to tap those people and utilize their commitment for this purpose. While positive strides in providing legal aid are no doubt underway across, there is still a long way to go, as I was mentioning. Justice Goodwin Liu, Associate Justice of Californian Supreme Court, while referring to the statistics on access to legal aid in the United States, a different cup of tea, said, but I think the wordings are important. I quote, "If you filled a stadium to its capacity, you'd have 7 lawyers to serve all the people that need legal aid. And if they gave each client just 30 minutes, it would take them 7 months to meet with everybody. and that's working around the clock 24/7 without breaks. It is no wonder the majority of low-income people in our country don't bother to seek a lawyer, and even when they have a very serious problem, to lower these barriers to justice, we all have to share and then sing. This is US, which is supposed to be a developed country. It's not that these problems don't exist in other countries, and we are a very large section of population, a very large section of the underprivileged people. The magnitude is very large, and therefore what you are doing in the paralegals carry on the most important work. It can be a transformative role here by not only carrying forward the mandate of legal services institutions, but also filling in the gaps of the administration. Such examples of gaps include unavailability of probation officers, welfare officers, correctional officers in prisons, etc., resulting in dismal implementation of transformative legislation such as Probation of Offenders Act. In essence, the PLVs embody the ethos of inclusivity and empowerment within the justice system. Their tireless effort not only addresses immediate legal need, but also fosters a culture of accountability and equality. As we navigate the complexities of a dynamic society, let us recognize and amplify the indispensable role of the paralegal volunteers in our collective pursuit of justice for all. In the end, let me say, I endeavored at something as a judge, but not very successfully. And I think some build-up is necessary for it. In a judicial order, I had passed saying that, look, if you're celebrating 75 years of independence of this country, why can't we have a system where instead of every case going through a trial right till the whole trial is complete, appeal in Supreme Court, plea bargaining having not succeeded in our country because people don't want to take that stigma, say as compared to the US. Anybody who has served a certain percentage of sentence, maybe half or 33%, whatever is identified, is a single offense case, no multiple offenses, social economic factors coming in. Why can't we take a bond of good behavior and release him and take that case out of the system? This would help in the courts being able to concentrate on the more heinous cases of time and get rid of in one go of all the cases which are pending. Till I demitted office, there was no response to it. I hope somebody thinks about it and looks to how to both unburden the court systems and also look to petty offences, say, which carry sentences of 7 years or 10 years, being dealt away with a scenario where people have served a certain sentence, have gone through as under trials that corrective process. We can't have a system where we can't get convictions, but the sentence is only by keeping persons in prison during pending the trial. Thank you very much.
Thank you, Justice Kaul, for your insights. We have much to learn from your vast experience, clearly. I'd like to request Poonam to come on stage. Poonam is one of our community-based paralegal volunteers to present Justice Kaul with a token of our appreciation. Thank you, Poonam. Moving on to our next segment. In the run-up to this conference, MAP had undertaken a rapid